or net miss, but it had a typo error, and we therefore filed another one today, which is dated 29th of May, 2025.
Yes, sir.
And we also served that on to defense. Counsel for first applicant, second applicant, and the third applicant. And a copy of the same is on record. It is there, it is on that background, Your Worship, that we invite this court to proceed under section 168 of the Magistrate Court Act.
Please, as you record, be mindful not to.
We invite court, Your Worship, as under section 168 of the Magistrate Court Act, Cap 19, to have the accused persons, the indictment and summary of offense, the case read to the accused persons and have them committed to the High Court for trial. So,
Where is the indictment and summary?
there's a copy, we filed a copy, but I can patch you with another copy here, dated 29th.
Yes. Yes.
Yes, Your Worship, once again, I don't know whether you intend to proceed, whether it's commitment or whatever the prosecution wants to be done in the charges that have been read for us when we are not represented.
Yes, I want to say something. Your Worship, first of all, this matter, initially, the lawyers have been in court and they have been on record. And it is on record that the accused person is represented. When this matter came up, for ruling on whether or not this court would refer this matter for revision on its own initiative, and the court said no, the accused person instructed his lawyers to move out of court, which is not the usual practice in how court conducts its business. It was not fatal for the accused person and his lawyers to wait and listen to prosecution before they would make a protest move out of court, which we as prosecution condemn. And this has not been the first time. Even last time, counsel for applicant moved out of court. And indeed, the accused person denied his lawyer. Yet he had been put on record. And after ruling, the accused person said he never gave them instruction to proceed any further. And the lawyers moved out. The process.
Just keep it brief.
No, I'm finishing now. The process that we are undergoing, yes, the accused person requires, he has the right of legal representation right from the start up to the end of the criminal matter. But the process that we are undergoing right now is not fatal. It's not fatal to proceed without the lawyers who have actually deliberately moved out of court. Because that is an attempt to dictate on what court has to do, on what prosecution has to do, and I think we shall go nowhere. The process of having the charges read and a committal process as per section 168, in fact, the DPP is not supposed to come and present the committal papers physically. The law says we are supposed to file, and once we file them, the accused person, it is the duty of court to read out the committal papers to the accused person. It is not a prerequisite for us to come and say we are bringing them. So prosecution or DPP, Office of the DPP, will have discharged this duty by merely filing. This is what we did. We filed these papers, committal papers, on FMIS, where the accused lawyers are linked. But let me read this section, Your Worship, just for everyone to understand. This is section 168 of the Magistrate Court Act, Cap 19. It says, where a person is charged in a magistrate's court with an offense to be tried by the High Court, the Director of Public Prosecution shall file in the magistrate's court an indictment and a summary of the case, signed by him or her or by an officer authorized by him or her in that behalf, acting in accordance with his or her general or special instruction. 168.2. The summary of the case referred to in subsection 1 shall contain such particulars as are necessary to give the accused person reasonable information as to the nature of the offense with which he or she is charged. 3. Just allow me, this is very important. When a person charged with an offense to be tried by the High Court appears before a magistrate and the Director of Public Prosecution has complied with the subsection 1 of the Magistrate's Court, which we have complied with because we actually filed the indictment and summary of the case. We have complied with that. But now the section says if the DPP has complied with that, what is next? The magistrate under 3A give an accused person a copy of the indictment together with a summary of the case, which we have given on FMIS. Because in FMIS, by virtue of that, we have.
Summarize.
So, and then B, read out the indictment and summary of the case to the accused person with the nature of the accusation against him or her in the language he or she understands, and inform him or her that he or she is not required to plead to the indictment. Your Worship, this provision, even without doing this formality, for as long as we file, the DPP has complied with the law under section 168 of the Magistrates Court Act. Therefore, the proceedings right now are regular. They are legal. Even without the accused being represented, because the lawyers will do nothing in this process. It is self-explanatory. They have no input, apart from being informed. But again, this scenario is again different, that the lawyers knew of this, but they have chosen to move out of court. So you are in order, you want to proceed with the committee.
Let court make its ruling.
If I reply?
Okay, reply.
Your Worship, you know, again, if it was about condemnation, having said what I have said about the DPP of Uganda versus me.
Just keep it summarized.
Yes. You not only need condemnation, you need to be in prison. People who falsify evidence to incriminate a law-abiding citizen cannot be served by only condemnation. So, Your Worship, our lawyers did not go out in protest. They went out with our instructions, as I pointed out, to do what was most urgent in the circumstances. Because they have been following this matter here. Now, unless you suggest that court or DPP will also guide me on which lawyers apply on which matter concerning this case, I should then be given the liberty, just like my colleagues, I believe, to choose which lawyers to attend to which at what time. And all I'm saying is, we are the ones in prison. So we are not going to run out. We are saying, give us time. These, we shall get lawyers to deal with this matter when you fix it. But proceed as if, because we have asked our lawyers to pay attention to one thing, we therefore forfeit our right to be represented. Would be unfair, and I request that you don't proceed with that, because fair hearing is the process of the whole case. And as I have emphasized over and over again, it's a case that can end in death. So what is the hurry in not allowing us the latitude to be represented by those we want to be represented by and pursue what is urgent by those who need to pursue what is urgent? I request your worship that you give us another day when this matter can proceed with our lawyers. And if it is not entertained, maybe you entertain me to seek a constitutional reference to find out whether indeed that right